A common phrase we often hear is, "Nothing is new under the sun." Do you dream about ideas for inventions, but wonder if you're really the first to think of them? Millions of people around the world hope to make their ideas for an invention a reality. Some take the bull by the horns and begin to bring their vision to life. It's a well-known fact that obtaining a patent gives you exclusive rights to sell your invention, and many inventors wonder, do I really need a patent attorney to file a patent application? I spoke to Thomas Octoloni, a patent attorney who provides legal protection for technology gadgets. Mr. Octoloni, for those who might not know, what does a patent attorney do?
A patent attorney is a guide in order to help you, the inventor, obtain protection for that precious invention. It's not required that an inventor seek the assistance of a patent attorney, but it's just a really good idea.
An inventor that has a great idea for a new product or service, what are the first things he needs to do in finding the right patent attorney?
Well, first of all, the inventor has to have a clear idea of what the invention is. And then seeking out a patent attorney or a patent agent is in many ways like finding a good doctor or a good mechanic. Mm-hmm. It involves finding someone with the right technical background.
Absolutely.
If your invention is a widget or a little mechanical invention, then probably you should be looking for someone who has training in the mechanical disciplines. If your invention has to do with chemistry, then you want to find someone whose technical training is in chemistry. And it's also important to have a good rapport with your attorney, because the exchange of information is vital to ultimately preparing and filing a good patent application. There's much that goes into a patent application. Mm-hmm. It's not merely just a document that satisfies certain technical requirements. In my opinion, it should also be like a sales brochure, with the idea that you want to engage the attention of the examiner and help the examiner understand that this is a great invention. It does merit patent protection. And too often that opportunity is lost when a patent application is drafted. It might meet the requirements, the technical requirements. It'll have a detailed description, it will have drawings, it will have claims, but it will just lay there and not really engage the examiner. And that makes obtaining the protection you deserve a lot more difficult.
Now, to find that right patent attorney, does the inventor ask around, do a Google search?
Yes.
How can you be sure that this is the right person? Do you interview, like when you have a list of people, call around and interview each person, or ask for patents that they've executed in the past, just to see a track record of their work?
Well, I think that's a reasonable request to ask for samples. Mm-hmm. You can also, certainly word of mouth, if you have someone that's had experience filing patent applications and has had a good experience, that's very valuable. I don't think that it needs to be an exhaustive search where you have to interview tens, dozens of patent attorneys before settling on the right one. But certainly doing a little bit of research through the internet, looking at that person's biography, looking at perhaps some representative clients, that sort of thing. Some of that information varies firm website to firm website. Mm-hmm. Some are more detailed, some are less detailed. I still think, though, having that conversation with the attorney or the agent is important. And keeping in mind that an attorney or an agent should be willing to spend a short amount of time with you. That person probably will be unwilling to get into the details of your invention immediately, but you can speak briefly enough and in enough generality that you can get a sense of whether this person is somebody I'd like to work with, or whether, no, I'm not so interested.
Okay, so if you find the right attorney, you're
Yes.
good to go. What is the average cost?
Again, it's very hard to give you a specific dollar amount because it varies for a number of reasons.
Range?
Let's say, if you're filing, so to file an application, there's the cost of the USPTO, the Patent and Trademark Office fees, plus the attorney time. So putting aside the USPTO fees, and again, depending upon the level of complexity of the technology, a rough ballpark could be $4,000 up to $14,000 in attorney time to draft the application itself. And that being the text, the supporting text, and drawings. Most applications have drawings, but it's not a requirement.
Now, for inventors who cannot afford to pay the fees, are there other options, like, say, a pro bono lawyer?
There are. I don't think the options are extensive, but the options are there. With the America Invents Act, AIA, of 2011, one of the aspects was an encouragement to the Patent Office to work with state intellectual property law associations to develop pro bono programs. At this point, there are about 21 programs, including that of the District of Columbia, and the extent of their development and how they operate varies from state to state. Also, and an inventor can obtain information about this from the USPTO's website.
Very briefly, how does an inventor qualify for pro bono services?
Well, there are three requirements. There's a maximum income requirement. Also, there's a requirement that the inventor demonstrate a minimal knowledge of the patent system, and also that the inventor must possess the invention. And that, as far as possessing the invention, the program requires that someone really have a very definite idea about what the invention is, as opposed to, I've got an idea, I'd like to sort of talk a little bit about the process. So, for example, if you filed a non-provisional application already, that certainly is evidence that you possess the invention. Or if you have a detailed written description and some drawings, that's more evidence that you would provide to satisfy the requirement that you possess the invention. As far as working knowledge of the patent system, the USPTO provides online training that results in a certificate of, I'm not sure of the title, but it's a basic patent system knowledge certificate. And if you are able to produce that satisfies the requirement, that particular requirement.
Okay, for inventors who want to save money and file the applications themselves without a lawyer, how many are successful doing so? Again,
I don't have hard statistics. I know that number is relatively low. You mentioned, I'm a former examiner. During my time, I can remember distinctly only very few applications coming across my desk that were pro se. And those applications always encountered difficulty just because of the unfamiliarity with the very many procedural aspects of filing a patent application, but also because the inventor didn't really understand the substantive aspects of filing a patent application. And the inventors were certainly earnest in their desire to obtain a patent, but oftentimes they will look to the examiner for the assistance that they probably should be getting from an attorney. And that puts an examiner in a difficult position because the examiner is there to essentially represent the interests of the public at large. He or she's an employee of the patent office and really is not in a position, is not authorized to provide advice to the inventor. So even before you file your application, before you get to the point where you're interacting with the patent office and with the examiner in particular, there are issues that arise. So when you prepare a patent application, there are many requirements that it must satisfy. And a basic basically a patent application must have a written description that can, as I mentioned, can be simply text, although almost always it includes some sort of drawing or multiple drawings. Plus it includes a section of claims. And very often inventors struggle with the concept of what is a claim because it's a unusual sort of legal animal. And to give a quick analogy, so if I've purchased a piece of property, real property, a piece of land, it's common for a landowner to place a fence around the border of the property to say, this is mine, this is where my property extends. Well, for a patent application and for patents, claims function very much like fences, but it's not one for one. And in order to obtain a patent that has robust protection for your invention, you really have to understand claims.
Are there boundaries to drafting claims?
Well, yes. So you must not present a claim that requests a scope of protection that's so broad that it covers known technology as well as your own invention. Ideally, when the inventor or the patent agent or the attorney drafts a claim, it should be broad enough that it just includes a little point of novelty that captures your contribution, your invention. Many of the other elements of the claim will be common with what was already known in the prior art, but you always need to include that point of novelty. And then there are additional claims that you write, we refer to them as dependent claims, that continue to add details that introduce more and more aspects of your points of novelty.
Are U.S. patent claims recognized worldwide?
Well, no, in the sense that a patent in the U.S. is only a useful tool in the U.S. But traditionally the standards and the requirements of a U.S. patent application have been among the most rigorous. So it's been common to draft an application so that it satisfies the requirements of the United States and then to turn around and use that application as the basis for filing overseas. That doesn't mean there aren't adaptations that are required for the different patent systems around the world, but that's a very common practice. And I should also acknowledge that while our system, we consider it certainly to be robust, another reason why that's a common practice is that for many years the U.S. market has been the greatest market in the world. So companies will ensure that their intellectual property is adequate here and then can leverage that property elsewhere. For example, by using a patent application drafted in the United States as a basis for filing overseas. A common technique for doing that is filing an application, a PCT application, Patent Cooperation Treaty application. So it's just having U.S. patent doesn't help you per se outside the U.S., but it typically makes it easier to establish rights outside the U.S.
So if I obtain my patent here in the U.S. and I go to another country that the patent is not recognized, is there a possibility that I, as the inventor, could be sued for infringement if there is a similar product in that country, a similar invention?
Well, if there is a patent holder in that other country and you enter the market with your product, even if you were the first to invent, yes, it's possible, but at that point, there very well may be the opportunity for you to defend on the basis that their patent is invalid, for example, because of not being either the first to invent or the first to file, that sort of thing.
Patent litigation can be very lengthy and expensive. How can an inventor avoid legal issues once his patent has been issued and his product is in the general market?
I think what you're describing is a situation where the inventor has his invention has been patented, and now the inventor has concern that a competitor may be infringing the patent. So in that situation, the inventor, who is the patentee, the patent owner, must proceed carefully, because in the United States, certainly, if a company or if a party is accused of infringement, there is the possibility that that party could file a counter suit, meaning a declaratory judgment action. And in that situation, even if the patentee thinks that that person or that party is infringing, the patentee may not be ready to go to court just yet. But if the accused party files a declaratory judgment action, then the patentee will have to answer and will lose, for example, the home field advantage, in the sense that if you're the patentee and you are prepared, you've done your homework, you're ready to go and file suit, you choose the forum. You choose the court, the district court in which you want to file the lawsuit. But if you're not careful and you put that other party in fear of you filing suit, and that party then files a declaratory judgment action, that party has the opportunity to choose the forum, the court. And that may not really suit you.
There's always the option to settle out of court.
Oh, of course, of course. And most patent lawsuits do settle out of court because, as you correctly identified, patent litigation is terribly expensive. It's terribly expensive. And frankly, the expense of patent litigation is one reason why an inventor should think very carefully about obtaining a patent application on his own as opposed to hiring either a patent agent or a patent attorney, because the expression penny wise and pound foolish comes to mind. You know, yes, you can get a patent, but if you have hopes of that patent being really useful in litigation, then you want it to emerge from the patent office with a very clean record, a very brief record, because the longer the prosecution, meaning the longer the length of the record that was created when the application was being examined. So the longer that record, the more opportunities there are in it for a future opponent to find weak seams and attack it. Because when you go into court, if you're the patentee, you accuse a party of infringing, well, the patentee can defend on the basis that, no, my actions or my product really don't infringe. Or that party can say, it doesn't really matter if I infringe because I think your patent is invalid.
If they can prove it.
Yes. Or that party could say, well, your patent, I may infringe, and your patent may be valid in terms of its relationship to the known prior art, but there are some things that took place, some behavior that took place during prosecution that now renders the patent unenforceable. Those are three ways that the accused can sort of get out of the predicament that the accused is in.
What type of behavior would that be? An example that would render that patent inapplicable?
Well, unenforceable, actually.
Unenforceable,
yes.
Sorry.
That's okay. The classic example for how a patent ends up being held unenforceable by a court concerns the requirement during prosecution that the applicant, which is typically the inventor or inventors, disclose the closest art of which the inventors are aware. And what might happen is that there may be a miscommunication, for example, between two inventors. One inventor has a much better idea of what prior art exists, but because they're working together, the first inventor says, I'll handle that area, and asks the second inventor to be responsible for preparing and filing the application. Fine. Only the first inventor fails to tell the second inventor about all the references that he knows about. And as a result, the first or the second, inventor doesn't disclose them to the patent office, and they never become part of the record. The examiner is never aware of them. Well, later on, if that patent is important in the market, has value, during litigation, you can be certain that the accused infringer will find out that the first inventor knew about all those references and for some reason never disclosed it to the patent office. And at that point, the inference will be that it wasn't just an honest mistake. Rather, the inference will be that you're hiding something because you knew that that art was going to knock out the patent. Now, that's a simplified example, but in that situation, if it was true that there was really relevant art there and it would have changed how the examiner viewed the invention and perhaps changed the scope of the claims that were granted, then it's very likely that the court would find that there was an inequitable conduct. Or, sometimes people talk about unclean hands. And very well, the result could be that the patent would be held unenforceable.
I would think the patent examiner would have found out during the patent filing process that there is a similar product.
Well, examiners do conduct their own searches. Mm-hmm. That's right. And it's important to realize, the patent examination process oftentimes is viewed as from sort of an ideal perspective. And that's really unfair to the patent office and to examiners in particular. Examiners are only allotted a certain amount of time to spend on each application on average. And so while the examiners are diligent and they will search, it's not possible for them to search everywhere. And there are many instances in which the most relevant prior art, mm-hmm. most relevant references exist, but they're not in places or databases. They're not readily available to the examiner. The examiner will certainly look in the existing patents. They'll search the published patent applications. He'll search the granted patents. And depending upon what area of the patent office you're in, depending upon the technology, the examiner may or may not spend time searching other prior art databases, journals, publications, that sort of thing. But it's very possible that some of the best prior art is simply not going to be discovered by the examiner. And under our system, the applicant is required when the applicant knows of art to disclose the art.
Absolutely. And a patent has a certain duration.
Yes, 20 years from the earliest effective filing date.
And after 20 years, it's open.
Yes, and that's sort of the basis of the patent system. It's a quid pro quo. So in exchange for the inventor disclosing how to make and use this invention for a limited amount of time, the U.S. government grants to that inventor the right to exclude others from making or using it. But once your period of exclusion, once your patent term is finished, then that knowledge is freely available to the public.
Can you renew?
You can't renew. You can't extend one patent. But what happens is that companies or inventors will file applications on incremental improvements. So even though the first patent application, its term has finished, there is a later filed improvement that at that point effectively covers at least the improved version of the invention.
Mr. Octoloni, it's been great having you here on this show. Thank you so much for sharing your wealth of information with us.
It's been a pleasure talking with you. Thank you very much.
We hope you've gained immensely from our discussion on why an inventor needs a patent attorney in the patent filing process. If you have any questions or comments, please send an email to info@firstofitskind.com. We look forward to hearing from you. Thank you for staying tuned.